Unreasonable refusal to rehire claims. These are kind of interesting too. It's a penalty built into the Workers' Comp Act under Chapter 102. You see where the site is for that. And the basics of it are, it's like, well, if an employer, and this is the second point under the heading there, any employer who unreasonably refuses to rehire an injured employee has exclusive liability to the employee for up to 1 year's wages. That exclusive liability is important because your workers' comp insurance company is not going to pay for this. The statute clearly puts that on the employer if there's an unreasonable refusal to rehire the injured employee. These claims get made a lot. Some are legitimate, some are not. But you as the employer are responsible for the defense of those claims, and also if there's a judgment or a settlement, you're responsible for paying that. Again, the penalty is up to 1 year's wages. Sometimes those are negotiated, sometimes they're just used as a bargaining chip, but it has to be in an application for hearing at the Workers' Comp Division. Okay, that's where those get filed, and they look a lot like a discrimination claim, but they are not. They're part of the work comp system. And again, the work comp carriers do not pay for this because the statute specifically says that, and case law has confirmed that. Now, a lot of companies out there also have employment practices liability insurance, referred to as EPLI. That's not a workers' comp policy. Almost all of the EPLI policies specifically exclude workers' comp, and so you're probably not going to find coverage there for that. So you are on your own for these. So again, be very careful if you're going to fire somebody, what's the purpose, and to be able, if you have to fire them, to be very clear about why you're firing them, etc. Another penalty that employers can run into are safety violations. Employer and employee. If the employer, and I'll just simply kind of read this off, it's under 102.57. If injury is caused by a failure of the employer to comply with any statute, rule, order of the Department of Safety and Professional Services, and that includes failure to enforce employee compliance. So if an employee is doing something unsafe, in violation of the rules, and you don't enforce it, the employer is still in violation for that. If that's what causes the injury, then the employer shall pay an increase of 15% of the indemnity payments up to a total amount of $15,000. So you'll pay 15% on top of your TTD. You'll pay 15% on top of, if there's a PPD settlement, there's a 15% penalty up to $15,000. I've seen that happen, and that's exactly how it plays out. It's not OSHA though, OSHA violations. It can be used as a basis, but OSHA violations are something different than this. The employer has the primary responsibility. So who pays the penalty? The employer does, not the work comp insurance company. But if the employer goes out of business, let's say, the insurance company is secondary to that. They'll pick up if the employer goes out of business, but the employer pays these typically. Now there's a flip side to that. If the employee violates safety rules, although I've never really seen these happen too much, so these are kind of rare birds where these get actually applied. If an injury is caused by the employee's failure to use safety devices, provided in accordance with any statute, rule, or order, and the use of the safety is required by the employer and enforced by the employee can have a reduction in their indemnity payments, their compensation and death benefits. So their TTD, their PPD, etc., there can be a reduction of 15% up to $15,000. Medical bills are excluded from that. So the full medical bills get paid. There's just a reduction in the indemnity payments. Not easy to enforce this against employees. I don't know how often it even happens, to be quite honest with you. There's some case law on it, but again, day to day, I'm not sure how often it even comes up.